All right, happy Friday. Today we're going to be talking about paid leave policies. My name is Cindy Flynn and my firm, as you all know, Hackler Flynn and Associates. I've had a lot of coffee this morning, so just a fair warning. But before we get started, I do have a disclaimer for you that content on this webinar should not be considered legal advice. It really is for informational purposes only. Communications made through and or by participating in this webinar do not create an attorney-client relationship, although we're always happy to do so afterwards. And in addition, we're not responsible for any content that you may access from third-party resources. All right, so today's topics: mandatory paid sick leave, vacation policies, unlimited PTO, and then some best practices that you can take and implement in your business. With paid sick leave, California's Healthy Workplaces, Healthy Family Act went into effect in 2014, and it requires employers to provide a set amount of paid sick leave to employees working in California. A lot of companies we've been representing this year are actually out-of-state companies who are headquartered in Texas or in Florida, and then they have some people working for them in California, and they don't quite realize all of California's rules and regulations regarding sick leave. So hopefully this clears it up for you. And although the Act establishes minimum requirements, employers have the option to provide more time off than the minimum required under the Act. So you can always be more generous to your employees. You just can't be less generous than what the law provides. In addition to California's mandatory paid sick leave law, multiple jurisdictions also provide mandatory paid sick leave benefits on both the local and the national level. There can be significant differences between the state law and the local laws. So make sure you're checking the specific area in which your employees are working, if they're working from home. We've had clients where they have somebody working out of LA, they have somebody else working out of Fresno, and they have to provide additional sick leave for those employees in LA as opposed to other parts of the state. So just be careful that you're looking in the exact area in which your employee is working out of. And it becomes difficult when you have remote employees, as we all have had over the last year and a half, especially, or really since COVID started. And then you may have employees moving between various cities for work, of course, which also can cause an even bigger compliance challenge. So unlike other leave laws, such as state or federal family and medical leave, which is CFRA or FMLA, there's no employer size requirement for paid sick leave to apply to your company. The law applies to all employers, big and small, with only a very few limited exceptions. And in addition, paid sick leave is a form of protected time off. So unlike vacation, paid sick leave is not considered a form of wages. And it's recommended, as your employment attorney or a friend, that you create a written policy showing compliance with the mandatory paid sick leave law. A written policy, of course, can help you clearly communicate your company's approach to providing the mandatory benefits. A written policy should also be used if you place any limits on paid sick leave that are allowed within the law, such as a cap on accrual or something along those lines. All employees who on or after July 1st, 2015 have worked in California for the same employer for 30 or more days within a year from the beginning of employment are entitled to this paid sick leave. There are only limited exceptions, but part-time and full-time employees are covered. Exempt and non-exempt employees are also covered. Temporary, seasonal, and even out-of-state employees can be covered too. Out-of-state, it's if they spend enough time working for your business here in California. So it gets a little complicated if you have employees moving in and out of California or coming to California occasionally to work. The following groups of employees are not covered by the Act and therefore are not entitled to paid sick leave. And that includes employees covered by a collective bargaining agreement that provides for sick leave, has binding arbitration, and meets other requirements, including a regular hourly rate of pay of not less than 30% more than the state minimum wage. Construction employees, so if you're one of our clients that is in the construction industry, it doesn't apply to them under certain types of collective bargaining agreements. Providers of publicly funded in-home supportive services under certain sections of the welfare and code, and then certain air carrier employees who are provided time off that is equal to what is provided under the act, and then certain public retired annuitants. So the amount of sick leave an employee can earn and or carry over will vary depending on how the employer decides to handle the provision of leave. The Act provides employers with various options in which to satisfy the requirement to provide employees with paid sick leave. So employers can actually choose between 4 different accrual methods and one lump sum method that avoids accrual and carryover requirements. With the accrual methods, employers will also want to examine the option to cap accrual of paid sick time within the limits of the Act. The lump sum method is less administratively burdensome. You just give them a flat lump sum every year, but with caps, we always recommend putting a cap, but let me go over some of the options first. So one is the statutory mandated accrual method, which is 1 hour per 30 hours worked. That's how it accrues. Then you have the option of an optional accrual method that provides no less than 24 hours by the 120th day, which is similar to the statutory accrual, but allows leave to be tracked by pay period instead of hours worked. An alternative accrual method for new hires is satisfied if you, the business owner, provides no less than 24 hours to be used by the completion of the 120th calendar day of employment. And then a pre-existing employer policy that went into effect prior to January 1st, 2015, which please tell me you've updated your policies in the last 6 years, or a lump sum approach, which front loads the paid sick leave without accrual or carryover to the following year. So that's totally fine there. And then just one more note on paid sick leave and calculating that leave. Employers who use one of the accrual options will also want to consider placing a cap on the maximum amount of paid sick time that can be accrued. So keep that in mind. An employee can use paid sick leave for the diagnosis, the care, the treatment of an existing health condition or preventative care for themselves or for a family member. So for example, here an employee can take this paid sick leave for a cold or other sickness, for a sick child, or for an annual physical, or another preventative care like the flu shot. And a family member under California's sick leave law is either a child, and a child is somebody, it actually is a definition of what that means. It's a biological, adopted, foster child, stepchild, and it now has been expanded regardless of the child's age or dependency. So if you're 60 years old working, if you have an employee who's 60 years old and working and they have a 30-year-old child, they can still take sick leave to care for that child. That changed this year in January 1st of 2021. Another type of family member is parents, or even now parent-in-law. Parent is actually defined again as biological, adoptive, or foster parent, step-parent, legal guardian, and other family members also include spouses or registered domestic partners, grandparent, grandchild, and sibling. And for those last three, grandparent, grandchild, and sibling, that is only related to California law under CFRA. And that is in place if your business is over 5 or more employees. Or if you're out of state and you have one person in California and you have 4 somewhere else, that still applies to that California employee because your whole business is over 5 employees. So we get a lot of questions on that. And okay, so there are important points regarding how paid sick leave can be used. Employees cannot start using accrued sick days until the 90th day of employment. After that, the employee can use the sick days that's accrued. Employers can limit the amount of paid sick leave an employer can use to 3 days or 24 hours per year. This limitation applies even when an employee under the default accrual method could have accrued 6 days or 48 hours, or even more if you didn't put a cap on it. And then paid sick leave must be provided upon an employee's oral or written request. If the need for paid sick leave is foreseeable, an employee must provide reasonable advance notice. If not, the employee must provide notice as soon as practicable. The Act does not say whether you can require the employee to provide medical certification of the need for paid sick leave, such as a doctor's note. The law simply says that the employee must provide reasonable advance notification. And the Labor Commissioner has stated that denying leave because of an employee's failure to provide a doctor's note or other details about the leave may lead to a claim against the employer for violation of the Act. Unless the certification is required pursuant to another leave law, there's no provision in the Act allowing an employer to require certification for paid sick leave. In addition, an employee may determine when and how much paid sick leave he or she or they need to use. The employee can decide if he, she, or they wants to take a full day or a part day. For example, you can't tell an employee that he, she, or they needs to take a half a day for a brief morning doctor's appointment. An employer, however, can set a reasonable minimum increment of time that must be taken not to exceed 2 hours. In other words, you can require the employee to take a minimum of 2 hours of paid sick leave at a given time throughout the employee's workday. And an employer cannot require an employee to find a replacement worker for their time off. And an employer can lend paid sick leave to employees in advance of their accrual. According to the law, this is at the employer's discretion and with proper documentation. Of particular note is that the law does not specify what proper documentation means under this provision of the law, but you can always reach out if you find yourself in that situation. And as a practical matter here, employers should adjust absence control policies that require a doctor's note when employees are absent for a set number of days. In addition, policies that discipline employees based on a specific number of absences should not count days off that are protected by this law or any other protected leave of absence. It's also very important that you post a required paid sick leave poster created by the Labor Commissioner. The poster advises employees of sick leave rights. The poster needs to be posted in a conspicuous location. And mind you, so many people are remote now, so you can send out your policies via email and then also put them in a group, folder, Dropbox, however your internal communications within your company are kept. That's totally fine. If you are a brick and mortar company, I don't recommend putting these posters in your break room because that's kind of when employees sit down to take their lunch break and then read on the wall all the way to sue you. So my recommendation is always to put it in like a hallway. So if somebody wants to stop and read, great, it's right there. It's not in a hidden location behind a door or something, but it's in a hallway, something like that. And then just one more note here on the poster that's created by the Labor Commissioner. Failure to post this can result in a penalty. It's $100 for each offense, but why go down that road? Employers also need to provide written notice of paid sick leave information to all new hires and existing employees. And you must provide an employee with a written notice setting forth the amount of paid sick leave available to the employee each pay period. You can provide this notice to the employee either on the already required itemized wage statement or in a separate writing provided to the employee with the payment of wages. And then in terms of record keeping, Please tell me you know my top 3 rules of employment law: document, document, and document. You will need to keep records for at least 3 years that document the number of hours that the employee worked, paid sick days accrued by an employee, paid sick days used by an employee. If an employer does not keep accurate records, there is a presumption that the employee is entitled to the maximum number of hours accruable unless the employer can show otherwise by clear and convincing evidence. Now, what I always hear from clients is, of course, we gave them, you know, their sick time, it's as much as they needed, or, you know, whatever that conversation is, and we can bring in witnesses to attest to that. Well, the presumption is against you as the business owner, right? So you have to go above and beyond to prove otherwise. And so it's just much easier to keep adequate records of this type of thing than to call witnesses in and eventually get sued for this and have to take depositions for each of those employees who can testify as to your practice. So keeping records is often the easiest way to avoid a lawsuit coming up in the future. And these records must be available for inspection by the labor commissioner. The records must also be available for inspection by the employee upon reasonable request, as with other payroll records. And then as a practical matter, it is easiest to provide notice to the employee on the wage statement itself or the paycheck stub itself. But you should also verify that the itemized wage statements provide this information and that payroll and record keeping systems properly calculate, track, and record paid and sick time. Okay, so the Paid Sick Leave Act contains strong protections for employees. I mean, there's really no surprise there. We're California lawyers. You guys are probably all doing business in California to some extent. And so as a result, employers cannot deny employees the right to use accrued paid sick days, take any action against an employee for using those accrued sick days or attempting to exercise the right to use them, retaliate against employees who file complaints alleging a violation of the act or who cooperate in an investigation or prosecution of an alleged violation or oppose a policy, practice, or act prohibited by law. And then, you know, you can't obviously retaliate by discharging somebody, threatening to discharge someone, demote them, suspension, or any other manner of discrimination. In addition, employers will be faced with a rebuttable presumption of unlawful retaliation if an employer does take adverse action, including denying the right to use sick days against a person within 30 days of when the employee files a complaint with the labor commissioner or alleges a violation of this law, cooperates with an investigation or prosecution of an alleged violation of this law, and then opposes a policy or practice that is prohibited by this law. As I mentioned, the Paid Sick Leave Act contains strong protections for employees. In particular, it contains various stiff fines and penalties for not providing sick days to employees, ranging from $50 to $4,000 aggregate, and allows for a civil action by the state as well. The labor commissioner is in charge with enforcement of these claims, and in addition to administrative penalties, can also order reinstatement, back pay, and the payment of sick days unlawfully withheld. So as an employer, you should review these policies and practices to ensure compliance, and you may want to consider including a reporting or compliant mechanism. For example, if an employee is denied paid sick leave by his or her supervisor, you could institute a process where the employee can go to HR and ask for a second check just to see whether he or she or they can actually take sick leave. One more thing on sick leave, and then we'll get into vacation. Employers are free to provide more generous policies than what must be provided under the Healthy Workplaces, Healthy Families Act. As long as you meet the requirements of the mandatory paid sick leave law, you can combine paid sick leave into a PTO policy in order to provide additional time off to employees for use when they are ill or injured. So for example, some employers might simply choose to provide a lump sum of 3 days or 24 hours of mandatory paid sick leave, and then have a separate amount of employer provided vacation or PTO, and some may just combine them into one PTO policy. If you choose the latter, to combine the two, just be mindful that paid sick leave laws will apply, and there are some downsides for the employer. For instance, you are not required to pay out accrued paid sick leave at the time of termination. But with PTO, on the other hand, all accrued and unused hours must be paid out upon termination. If you combine sick leave into a PTO plan, you will be required to pay out all of the PTO when the employee leaves. You can't then segregate it out and say, well, I'm not going to pay for 24 hours of PTO. And so with that, we'll move into standalone vacation policies. Vacation is a benefit that you can choose to offer your employees. Both are considered a form of wages that employees earn as they work. Under California's wage and hour laws, any unused balance must be paid at termination. If you choose to offer vacation time to employees, you must follow California law concerning vacation benefits. And if paid sick leave and vacation are combined into a PTO policy, you have to follow the laws I just mentioned regarding the paid sick leave. So a vacation, I hope you all get one next year if you haven't taken one this year. A vacation is any paid time off earned as a benefit. Any personal holiday, which is sometimes referred to as a floating holiday, that is not associated with a specific event, such as a birthday or a holiday, is treated as vacation. You can choose not to offer paid vacation time as a benefit. I get that question sometimes too from a little bit smaller of companies. If you do provide paid vacation time, you have the right to set how much paid vacation time employees can earn each year. You also have the right to determine when employees may or may not take vacations and the length of their vacations. So you can put some parameters around this. Paid vacation leave constitutes a form of wages. So PTO is also a form of wages. The right to vacation vests as the employee renders services. So in a typical policy, employees earn a portion of the annual vacation each day. And because it's considered wages earned, once an employee earns vacation, you cannot take it away. I just reviewed an employee policy from Texas, where you can do a lot more in Texas than you can here, but they had 3 employees here in California, and they had a use it or lose it policy, and then they got a demand letter and immediately, are working to fix that. But once an employee earns that, you can't take it away. California courts and the labor code prohibit a use it or lose it policy. I even had a law firm in California have a use it or lose it vacation policy. So lawyers get into trouble with this kind of stuff too. We probably represent a dozen law firms at this point. So what was I saying? California courts and the labor code prohibit the use it or lose it policy, right? In which employees lose earned vacation if it's not taken by a specific time. Now, you cannot require employees to forfeit accrued vacation for any reason, with one limited exception of a collective bargaining agreement, which expressly waives the labor code's anti-forfeiture provisions. And because vacation is a wage, you must pay out all accrued but unused vacation when the employment relationship ends. You must pay out even for an employee who has accrued vacation that he or she or they was not yet eligible to take. So for example, their employees may start to earn vacation immediately upon being hired, but might by company policy be required to work 1 year before using any vacation time. If that employee quits after a few months, you still have to pay that employee out the prorated vacation, since it is a vested benefit. And though you can base your vacation accrual policy on the week, pay period, or some other time period, you must base computation of vested vacation benefits for a terminated employee on the employee's daily accrual or vesting, including the final day of work. The vacation paid at the time of termination must be prorated on a daily basis and at the final rate of pay at the date of separation. You must pay out accrued but unused vacation at the employee's final rate of pay, regardless of the rate of pay at which it was earned. So an employee who earned 10 hours of vacation while making, let's just say for use of numbers, $10.50 per hour, who is then terminated or quits while making $12 per hour, will receive $120 in vacation wages on the final paycheck. Similarly, an employee who receives a cut in pay will receive his or her or they's vacation pay at the lower rate at termination. So it's whatever the rate is at termination. And the labor commissioner will probably not tolerate lowering of an employee's pay rate, pay rates just before termination, so you can avoid paying them a little bit more or their fair amount of earned vacation. So keep that in mind. We sometimes have clients who want to do that. If vacation is offered as a benefit, the law does not require that the accrual begin on the first day of employment. So that is something you can work into your handbooks as well. An employer may set a waiting period before vacation accrual actually starts. The employer is free to determine when an employee becomes eligible for vacation benefits, so long as eligibility and vesting occur simultaneously. Thus, a waiting period for vacation benefits to accrue and vest is permissible. For example, a California court recently ruled that an employee who worked less than 1 year was not entitled to vacation pay at the time of termination because the company actually had a lawful policy stating that employees don't start to earn vacation until after their first year of employment. So if you want to do that, we can work with you on a policy like that. The court said that if the employer's policy is clearly stated, the waiting period is enforceable. In addition, an employer may implement a reasonable cap on accrual of vacation. Under a reasonable cap plan, after an employee accrues a certain level of vacation but does not take the time, vacation no longer accrues until the employee takes some of the previously accrued time. And after the employee takes some vacation time, then he or she or they can then again start to accrue it again at the usual rate. But go back and look and make sure you have caps in your policies. It's just a good general rule. I had an insurance company come to me last week and say, he's taking over the business second or third generation, and there was no cap on vacation. So we're having to work together, but we can't take that away, right? You have to pay out all of your employees for that accrued vacation, and then you can set a new policy in place. So bear in mind that the cap should be reasonable based on factors such as the amount of vacation offered, the opportunity for employees to take vacation during the year, and the type of business or industry involved. In resolving disputes over vested vacation, the labor commissioner is to apply principles of equity and fairness. That's what they say anyways. Many employers impose caps at 1.5 times or 2 times the annual accrual rate. So for example, 60 or 80 hours for an employer who normally grants 40 hours of vacation per year. 60 would be 1.5 times, 80 would be 2 times the amount that they grant per year. And an employee must have a reasonable amount of time after the accrual to take the time before the cap is imposed. And the Department of Labor has repeatedly found that vacation policies that require vacation to be taken in the year earned or in a very limited period after the accrual period are unfair. So make sure your policy doesn't have any of that in place. And as a practical matter, employers should adopt a policy that specifies the amount of vacation pay an employee is entitled to accrue based on the length of service. When an employee starts his or her or they's employment, notify the employee when vacation accrual begins, the amount to be accrued, and then any caps or restrictions on the use of vacation. So company policies can require employees to give notice before taking vacation days. If an employee fails to report to work and then declares the missed day as a vacation day, you need not pay the employee for that claimed day. You are entitled to discipline the employee for failure to report to work in accordance with your policies, but be mindful as to whether the absence may be a protected leave, such as under FMLA or California's equivalent CFRA, CFRA. In addition, employers can choose to offer employees the option to cash out their vacation benefits. You can offer this option on an as-needed basis or allow it only at certain times, such as the end of the year. You can require your employees to accept pay each year for vacation time that they accrued but did not take instead of carrying vacation time over from one year to the next. It might be a good tax benefit by the end of the year. The cash out of vacation time must be paid at the employee's current rate of pay. Because of schedules and employee needs, you may allow employees to take vacation before they actually accrue it. Because the time is a form of wages, this practice is in effect a loan against future wages. If employment terminates before the vacation is earned, you will not be able to recover the advanced vacation wages by a paycheck deduction. To avoid issues of recovering in advance, you can create a policy that prohibits employees from taking vacation before they have earned it or accrued it. California employers often ask how can they handle a partial day absence for exempt employees without jeopardizing the employee's exempt status. Employers generally can't dock an exempt employee's salary when he or she or they is absent from work for only part of a day, but a California employer can replace salary on an exempt employee's partial day off by charging the time to the employee's vested vacation or PTO bank, provided the employee has enough time available when the absence occurs. It doesn't matter how many hours the exempt employee took off, the time can be deducted from an available accrued leave bank. However, bear in mind that employers can't dock an exempt employee's salary for the partial day absence if there's no leave in the employee's vacation leave bank. If the employee doesn't have enough accrued time off when the absence occurs, he or she or they must be paid for a full day if he or she or they perform any work that day. This issue comes up quite a bit, especially during this pandemic, and has continued as businesses remain understaffed. I mean, I'm just throwing it out here. If you know any excellent employment attorneys, we are hiring. I know a lot of companies are understaffed, whether you're, a professional service firm or you're a manufacturing company with, minimum wage earners. And so the question is, can employers deny vacation requests during a busy period? And the answer to that is yes. Employers can set up blackout periods and ask workers not to take time off until after the blackout period is over. As a practical matter, if an employer establishes a new blackout period, the company's vacation cap should be expanded to accommodate the hours accrued during the blackout period. Many employers have wondered if paid holidays are mandated. The answer is no. Private sector employers are not required to provide time off or premium pay for holidays. There are no state or federal holiday requirements for private sector employers, and holiday pay policies are a matter of contract between the employer and employee. Although paid holidays are not required, many employers offer this as part of their benefits package. Some clients have wondered if an employer can pay out vacation or paid time off hours at a lower rate of pay. I know we discussed this just briefly. The answer here is no. That would be a forfeiture of earned and vested vacation or PTO and in violation of the labor code. The code, in summary, provides that vacation is vested and requires unused vacation to be cashed out at termination at the ending rate of pay. Further, there can be no forfeiture, such as buying back at less than full value. Another example of forfeiture is that use it or lose it policy we discussed earlier. Unlimited PTO has been coming up a lot in the last few years, I would say. I think some big companies have, unlimited PTO options. They're rising in popularity, mostly because of one of California appeals court cases. This was an April 2020 ruling where the court said that under an employer's unlimited paid time off policy, an employee actually accrued vacation days as she worked and was entitled to be paid for unused days when her employment ended. This was not great for the employer. The court, however, limited the ruling to the facts of the case and said that if done properly, an employer may be able to construct an unlimited PTO policy that will not obligate the employer to pay for unused leave. So unlimited PTO policies are quite tricky. As a reminder, California law does not require employers to provide employees with vacation pay. However, if an employer does provide paid vacation, the labor code requires that the employer pay any vested vacation time an employee has not used at the time employment ends, and accrued vacation time is considered to be an earned wage. Okay, I see a question that's popped up. We currently have an employee switching from a full-time salaried position in our practice to a part-time position with no benefits. This is an internal switch. Do we technically need to close out and compensate them for their PTO and or paid sick leave? The answer is yes, you should do that. If they are switching from full-time to part-time and as part-time they have no benefits, pay them out for that. Absolutely. Great question. All right. The court here in McPherson held that Section 227.3 applied to this employer's unlimited PTO policy because the company never told the employee who was suing to recover unpaid vacation days that she had an unlimited paid vacation. That may have been the informal policy for employees in the position held by the plaintiff, but the company had no written policy or agreement to that effect, and its employee handbook did not cover employees who held the plaintiff's job. Other employees who were covered by the handbook accrued vacation that vested, other employees who were covered by the handbook accrued vacation that vested over time. In essence, the court said that this employer did not, in actuality, have an unlimited PTO policy. The court stressed that its decision was based on the particular facts of this case and went on to say that we by no means hold that all unlimited paid time off policies give rise to an obligation to pay unused vacation when an employee leaves. The great thing that the court did here is give a roadmap to employers on how to implement unlimited PTO policies correctly. And so the court concluded by offering pointers as to how an employer could craft an unlimited paid time off policy that might not trigger the labor code. Such a policy should be in writing, of course, and should clearly explain the employee's ability to take paid time off is not a form of additional wages for services performed, but is part of the employer's promise to provide a flexible work schedule, including employees' ability to decide when and how much time to take off, right? Having that flexibility. Number two, spell out the rights and obligations of the employee and the employer and the consequences of failing to schedule time off. Three, allow sufficient opportunity for employees to take time off or work fewer hours in lieu of taking time off. Four, be administered fairly so that it doesn't result in inequities, such as where one employee works many hours and takes minimal time off and another works fewer hours and takes more time off. The court stopped short, however, of saying that this policy would not trigger the labor code, but it's a good roadmap if you are considering something like that in your business. All right, I see a couple more questions I will get to in the chat. Hi, regarding the employer being allowed to deny payment of vacation pay when someone does not give any notice, does that apply to PTO as well? I'm not quite sure I understand the question. Regarding the employer being allowed to deny payment of vacation pay when someone does not give notice, does that apply? Vacation and PTO I'm using simultaneously. So maybe you can expand on that a little bit or email me and I'm happy to look at that a little bit further for you. I know you well. And then another question I see in the chat is, you mentioned earlier that in a combined paid sick time off or PTO and sick policy at the end of the employment relationship, the sick time like PTO must be paid out. Yes, that is absolutely true. What if the policy allows unlimited PTO and sick time? That's where it gets more tricky, right? And the court is saying you do have to pay that out, but it's like, how? You don't have a policy on it, right? It's unlimited. Take it when you need to. My biggest problem with unlimited PTO policies, though, is that you have somebody go out on leave or workers' comp, some sort of medical leave, FMLA, CFRA leave, and then it's, well, when does that end? When does your unlimited PTO end? Is it 1 year of pay that you're still paying someone? So unlimited PTO policies, I personally am not a huge fan of. We've written them for clients who really want to go that route and offer that flexibility. So there is some guidance from the court, but I personally, and this is what we do in our firm, we stick to, the standard. You get 80 hours per, 80 hours per year, 2 weeks, and then we cap out at 2 years worth. So everybody caps out at 160 hours. At least that's what we do. So just some best policies and practices that you might want to take back to your business. Review all your vacation or PTO policies just to ensure compliance with California law. Specifically, ensure that you don't have a use it or lose it policy or a cap on accrual that would be unreasonable. Ensure all wage statements provide employees with notice of their available paid sick leave and vacation PTO. That will satisfy the paid sick leave notice requirement and also serve to allow employees to track their available leave. Vacation and PTO are considered wages, which must be timely, paid out upon termination. If you fail to pay out accrued and unused vacation wages at the time of termination, employees can file a wage and hour claim with the labor commissioner or even a class action case against you in superior court. We have a class action right now in the office where, an employee worked there for 2 weeks. 1 week was training and 1 week was actually on the job and has filed the class action against my poor dear client. So it happens. One person can file a class action against you. If the employee wins, remember that he, she, or they can collect a waiting time penalty of 1 day's wages for every day that the wages were unpaid, caps out at 30 days. Additionally, at the time of termination, the employee would have a claim for any unpaid vacation wages accrued during his or her or they's employment. And that can easily turn into a class action case as well, even with just, okay, I see another question in the chat. I'm going to try and answer this. A little earlier, it sounded like I could deny paying out PTO to someone that gives no advance notice of their intention to take time off, i.e. employee says, I'm going away next week. So you can put limits on it. That's what I mean by that. So if you have like a very busy season coming up, if you're a seasonal business and December is your busiest season, you can deny use of vacation during that time period. And then your question goes on, if I did not or cannot approve that time due to lack of coverage, can I refuse to pay on PTO if he has accrued time off available? So you can put parameters on when somebody can use PTO. You can definitely do that. I hope that answers your question. Another best practice, employees can use vacation during other forms of protected leave like pregnancy disability leave and FMLA and CFRA leave. However, you cannot require an employee to use vacation during a pregnancy disability leave absence, but you must permit an employee to use vacation during pregnancy disability leave if the employee requests to use the benefit during their pregnancy leave. Ultimately, the employee makes the choice of whether or not to use vacation during pregnancy disability leave. Now, you can require an employee to use vacation during some Family and Medical Leave Act or California's Family Rights Act, that's FMLA or CFRA absences that are not related to pregnancy disability. Be mindful that if the employee takes leave under FMLA and the employee receives disability benefits such as state disability insurance, workers' compensation benefits, or other types of disability leave, you cannot require the employees to use vacation benefits during the portion of the leave when they are receiving those types of disability benefits. And then another best practice, clearly create a vacation policy and provide employees a copy of that policy. You want to include a couple things in your written policy: the time period during which accrual begins for new hires, the rate of accrual, and any incremental increases in accrual, such as for more years of service, you get an extra year, an extra week, any caps on how much vacation can be earned, any eligibility requirements or restrictions. And I think this is going to the heart of the last question that I was trying to answer. Any eligibility requirements or restrictions on the use of vacation and any required use, including during a leave of absence, any requirements that vacation be requested in advance in writing or be approved by a supervisor or other individual, the form or other documentation required to report vacation. So sometimes, clients have a form to document or request vacation. If you do not plan to advance vacation time that has not yet been earned, notify the employee that he, she, or they cannot take more vacation until it has accrued. You should regularly reconcile an employee's vacation accruals with the time that they've actually taken, and send written notice advising employees of the amount of accrued time remaining for vacation. So I hope that was helpful. No matter who you use as your employment attorney, do a couple check-ins with them per year. The law is always changing in employment. We do our best to not only keep up with it, which we're required to, but also to let our clients know, our friends know, any of our audience members know. California likes to update its minimum wage in January. Los Angeles likes to update it in July. We have California Supreme Court decisions that come down in February in the year, April in the year, earlier on. We have our governor who likes to sign new laws into effect in September. So make sure you're keeping up with them, and make sure they have an experienced team of attorneys behind them. Everybody here at this firm has at least 10 years of practice. And then you can do an early liability assessment, which I think can go in one of two ways. One, you can just do an audit of your documents. Has everything been updated in the last few years? Or really last year or two. We have had to update an employee handbook from 1972. It was a local nonprofit. Lots changed since then. And then the other thing is too, if you start to get a bad feeling about one of your employees and, they come in, we had this happen, they come into your office with a tape recorder taped to their chest, or they're starting to just act funny, they're starting to say, I'm going to document everything, I want this, I want that, you might know that something bad could happen. And so, it's sometimes good to dig a little bit deeper in their personnel file specifically. Are there infractions noted in their file, basically? And it doesn't even have to be like a formal write-up, but just, something that you've heard or them say, or something that should be noted, and you never know what helps later on. And so that's really where I leave it. I do have an employment compliance checklist. I'm sure most of you have seen it by now, but if you don't have it, I'm happy to send it to you. It goes over what's required for paycheck stubs, time records, a couple things that I find helpful for clients. And then I obviously love to stay in touch. If you got this, it's our firm hosting it. They can always stay updated. You can text HF Law to 66866. Get checklists, any up-to-date news. When the Labor Commissioner comes out with something, or the Department of Labor comes out with something, I want to make sure our clients, our friends, our audience members know. And then, of course, I'd love to stay in touch, email, phone, and office. We are ending a little bit early today, so I will give you 10 minutes back of your life. And thank you so much for joining. Really appreciate it. I hope everybody has a wonderful weekend.